Right, good morning, everyone. The time is 9:30, so we will reconvene the planning inquiry. This is the last session that we'll all be sitting here together, with the absence, of course, of Mr. Litton. And we are dealing with the planning conditions and the Section 106 planning obligation. As I explained in my opening, these are procedural matters that take place on a without prejudice basis. And at no point should be suggested that it's an indication that I have decided one way or another in relation to this appeal. Some housekeeping matters first. Unfortunately, whilst the appellant very helpfully sent in an electronic copy of the conditions and the Section 106 note yesterday, it didn't make it to me until this morning. So I'm afraid I haven't been able to circulate my comments on the planning conditions because I only had a paper copy, but at least I had that, which was helpful. So I'm going to have to go through them, and I'll flag up my concerns with them. And it might very well be that I can then issue an electronic note tomorrow. Okay. But thank you for the note on the Section 106 as well. I read that before I opened, and that was helpful. So thank you. I also sent in this morning, which I hope has been circulated by the case officer, a copy, or sorry, an electronic document in relation to the inquiry documents as I know them to be. Has that not been received yet? Have you just got it? Okay, so it's on its way then. So that was sent in this morning, and I have just flagged up in that email if there's any discrepancy between my notes and your notes, Mr. Green, and Mr. Litton's, if somebody can clarify with him as well, or if someone else has got a list of the IDs, to flag that up as soon as possible so that it can be rectified. In respect of the submissions that were submitted in the bundle yesterday from the interested parties, there were two documents that had already been submitted and they were duplicated. So I've ignored those, and that's that. So hopefully it should reflect accurately what we've taken in during the inquiry. Now, I don't have any further housekeeping matters other than the usual, please turn off the mobile phones in the event of a fire that way or that way through the fire exits to the field. Follow everyone else, I think, would probably be the best course of advice. So I'm happy to continue. Are there any housekeeping matters that the council wants to raise prior to doing so? No, splendid. And the appellant, any matters?
Just one, and it's really just to assist you, really. So we have already sent through a walking route for the site visit. To help you further, we are just updating that drawing to annotate on it the specific off-site highway works that are set out within and agreed as part of the conditions of Section 278. It's really just to assist you further, so that they will cross-refer to those drawings. So we will print an updated version of that plan with that additional annotation, and also print off the relevant Section 278 off-site highway works.
Okay.
So you have that in front of you.
That's helpful, thank you.
So just, forgive me, madam, just before I forget, I've been told that there are a number of residents who would like you to visit their properties on a site visit, whom you haven't already been told about. So,
oh, right. Okay.
So we will provide, I think, an updated list. Councillor Powell knows more about that than I do.
Okay. My intention is to do as much as possible to do the residents' visits first, and then do the sort of big walk after that. So if you could get those details into the council so they can come in, that would be helpful. Thank you, Councillor Powell. I have also received, which is just pinged up on my screen, the clarification note to the evidence of Miss Eade. So that's not included on my inquiry document table because I've just received it, but I will make a note of that. And all being well, and provided there are nothing's flagged up in terms of the inquiry document table, then that will become inquiry document 22. Okay. Any other matters to raise before we carry on? No, right. So, planning conditions. I don't have any comments. There are some typographical errors, so they will kind of be they would be picked up as and when in terms of missing words, singular rather than plural, that kind of thing. I don't propose to go through them in that sense because I just don't think that's an efficient use of time. I'm sure everyone is aware that those kind of things get mopped up naturally. So the first condition that I want to comment on is number 9. And to my mind, the latter part of that condition doesn't quite make sense. So it reads perfectly normally until second, where it says, and construction recommendations has been submitted to and approved in writing by the local planning authority. However, the first part of the condition says that a reserved matters application shall be accompanied by a scheme for the protection for the retained trees. And that scheme shall be carried out as approved. So I'm not quite sure how you can have it. Either the scheme will accompany the reserved matters application for consideration at that time, or you want a scheme to be submitted to and approved in writing by the local planning authority. And then you would normally link it to works taking place. So I'm just wondering whether or not we just remove has been submitted to and approved in writing by the local planning authority, and whether everybody's content that the condition would make sense on that basis.
Yes, that does make sense if the requirement is as set out to submit that information as part of the reserved matters application. You don't need the subsequent reference.
Super, thank you. So in which case, my note would simply delete that element of the condition. Now this is a drafting point that gets me all the time when it comes to occupation of a development, and I appreciate that you may have first occupation of the development insofar as you might have a sales unit or something like that, and that therefore the site is technically occupied for that basis. Or are you referring, when you refer here to the development hereby permitted shall not be occupied, or the development hereby approved shall not be first occupied, or you've also referred to prior to the first occupation of the development? There's also reference, I think, to occupation of the first dwelling. Do you intend for them to all mean the same thing? Because in which case it really ought to say the same thing for all of them, or it ought to explain why that's justified in one and possibly not another. Does that make sense? It's a sort of a consistency thing, but I feel like if what you're suggesting to me is that these prior to occupation relates to prior to occupation of a dwelling, then the conditions ought to say that. If your suggestion is that it's prior to occupation for some reason for the site, then again, that ought to be made clear.
Yeah, no, that makes perfect sense. I agree with the point. Consistency is important, and yes, I think the general accepted view that it will be prior to occupation of the first dwelling.
Right. Well, that's helpful because I think that's clearer as well in terms of tying it to a dwelling. And the first time that's mentioned is condition 14, where it says no dwelling shall be occupied until. So I think as a drafting point, the conditions that refer to other concepts of occupation need to be amended to the wording in condition 14 so that they're consistent.
Madam, would that include condition 10, for example, where it says the development hereby permitted shall not be occupied? Again,
And that's my point.
It's not precise, is it? Yeah.
That's
yeah.
my point,
So-
is that it either is, and that's why I'm suggesting that where it says development hereby permitted shall not be occupied until
Yeah.
the means of access for vehicles and pedestrians.
Yeah.
Now, is that suggesting that that's so that people can access the site for a sort of a sales perspective?
Mm.
Because if that's so, then that's okay, and that should remain, but that should be made clear.
Yes, what is being, or what is the trigger? Is it occupation of the site, of a
Yes.
sales property, a dwelling? Absolutely, madam, it should be clarified.
Yeah, agree.
Sorry, and it's just, I appreciate it's slightly pedantic, but I think you have to remember that if these conditions are going to be enforced at any point, then they need to be clear
Absolutely.
to be interpreted. Right, so condition 11, same point again with the beginning, and then A refers to reinstated faded yellow line markings on Crondall Lane, and I'm aware that there's some illegal parking that goes on Crondall Lane. However, is this, and I'm sure someone can assist me, are there yellow line markings the entire length of Crondall Lane, and are all of those going to be reinstated, or is there a particular section of Crondall Lane that this condition relates to?
I'm not sure I can assist too much, other than it is something that we'd also picked up latterly, admittedly. There isn't a drawing that refers specifically to where these works are, unlike the other off-site highway works.
Yep.
So we did have a conversation with the highway consultant, and he wasn't also able to assist very much. I think this has come directly from Surrey County Council,
Yeah.
but without necessarily being specific.
Yeah, okay, so that needs to be dealt with. We need that, we need it to be specific so that it's enforceable. Mr. Green?
Yes, yes, although it may be that there may be some time before the Section 278 agreement is executed,
Yeah.
and the condition today may not be the same condition as then, so there may be a need for some flexibility to ensure that at the time that agreement is entered into,
Yeah,
it's the condition then that applies.
and I take the point, so it might be a case of rewording it to say restating faded yellow lines on markings on Crondall Lane as identified by the Highway Authority.
Yes, yes.
And that might suffice.
Yes, or the final agreed Section 278.
Yeah, I'm happy with either, just as long as there's some element to that that is slightly more precise. Okay. And then in relation to E, it says pedestrian crossing improvements on the Hart at the junction with West Street. And again, I'm just concerned, is the Hart a pub?
No, it's not. It's a road. There is a drawing reference that can go with that. So I think that needs probably to be added into the condition, just to clarify.
Okay, right. Because I looked at it and I thought, I don't think I saw anything called the Hart when I was walking around, and I'm normally quite good at identifying pubs. So yes, so that just needs clarifying as well. That would be helpful.
Yeah, I think there is a specific drawing that is again referred to in Mr. Bell's proof. I think it's the same reference, but it's /17. So we will confirm that.
Super.
I believe that's correct.
That would be helpful. Thank you. Right. I don't have anything further on that, and I don't have anything on condition 12. Condition 13. Sorry, I should say, as we're moving through them, if there's anything that anybody else wants to pull up, then please do interrupt me. I'm perfectly happy for that. Right, so condition 13, slightly ambiguous in respect of, towards the end of the condition, it says, once agreed, the approved details shall be implemented to the satisfaction of the local planning authority. Now, I would suggest that if you are submitting details of layout for approval in writing by the local planning authority, that those should then be implemented in accordance with that approval, as opposed to the boundary, as opposed to the, it being slightly more subjective at a later date. So that should, so I think the tail, so that should be deleted, that sentence. And then the development shall be carried out in accordance with the approved details, I think is the tail that you need on the condition.
Yes.
Yep. Super. Condition 14, again, in relation to the dwelling shall be occupied, but we've dealt with that. And in terms of, actually, it might be in the scheme, but can we just clarify? So it talks about space being laid out within a site in accordance with a scheme. And then in terms of leaving that space free to be kept available at all times for those purposes, what's the mechanism for enforcing this condition? Is the scheme expected to include signage and things like that? Or is it just that it's laid out and then sort of left to the people that use the space to be trusted not to leave cars and things parked there? I ask purely from I'm sure we've all experienced when you go on some estates and you can see that the space has been left for turning areas and everything else, but is it then in fact used for parking, which has impacts on?
Well, the scheme itself could include signage.
Yeah. And that's fine if it's going to be mopped up by that.
Yes.
Then I don't have an issue. I'm flagging it up really as a.
No, yes, and you're absolutely right. It's something that the council is going to have to consider if this comes about. Not simply how the space is laid out, but as you say, how it's kept clear and so on. But that should be kept or swept up in the scheme itself.
Okay.
I should think.
Super. Thank you. Yes, Mr. Milson, could you put the microphone on for me, please? Is it not working? Mr. Milson, would you like to come and sit down in one of these, and then you might find that the microphone works. Yeah, they were. I think they.
Yeah.
Thank you for allowing me to speak. I'm doing this blind because we have not been sent or been able to acquire the Section 106 agreement or the conditions sheet that you're working from.
Right.
But I would make a point about what's just been said about signage, that it is important that signage includes the erection of powers to make bylaws on the Sangs land.
Yes.
Without bylaws being publicised, there is no power to enforce.
Yes, I think we're probably talking about slightly separate things in that the condition that we're looking at, which I've now lost, oh, here it is relating to hard spaces within the development itself for the parking of cars and things like that. So it's not relating to bylaws for open space or Sang.
There should be car parking available for the Sang.
This
and
site,
that would be included.
Mr. Milson, just to clarify, there isn't a Sang on this site unless
It's the public open space.
The public open space is not a Sang.
Right.
And I'm not aware that car parking is being provided for the use of the public open space as part of the development. That's correct. Yeah. So in which case, I'm not aware that parking, if the parking spaces aren't being provided for the use of the public open space, I struggle to, and they're parking spaces within the site. So the space being laid out in accordance with the scheme to be submitted to and approved in writing by the local planning authority for cars to be parked and for vehicles to turn so that they may enter and leave the site in forward gear. And that space shall thereafter be kept available at all times for those purposes. So it's for the functioning of the estate itself. It's not for the functioning of the public open space, and it's not to provide public access parking for the public open space.
But it's not the public open space part of the scheme. It is the reason for which the scheme is being made, that there is parking, public open space. If the public do not have the ability to park, then the public do not have access.
Well, I think this, I mean, I'm not going to start reciting the evidence of the appellant because that would be most untoward. However, to clarify, the public open space is to be accessed via foot, and it's been part by public footpaths, and that was part of the evidence of the appellant, the permeability of the site in order to access that public open space. The scheme before me does not include a SANG and does not include public access, a car park to access that public open space, Mr. Milton.
That really has not really been made clear. We assumed that the public open space was accessible by the public at large, not pedestrians only from the estate that is being built.
It's not, to clarify again, without sort of putting words in the appellant's mouth, but I'm pleased, Mr. Green, if you feel that I'm straying into a situation that I shouldn't, then please do tell me. But to clarify, my understanding is that the public footpaths cross the appeal site, as we've heard evidence on, and around the appeal site, and that those are being retained. And therefore you can access, the public will have the same level of access to the site that they have now. I'm not aware that any parking is provided currently to access that site. And that's not changing as part of this appeal. That's my understanding, and that's not been put before me as a matter for my consideration.
No, Madam, the public open space is dealt with in the planning obligation. The open space must be laid out in accordance with details to be approved at the reserved matters stage. And on completion of that, the public open space will be open to use by members of the public as public open space. And so there will be public access, but not vehicular access.
Yeah, thank you. That's helpful. And so it will come forward at the reserved matters stage as well. So before me at the moment is access and the principle because it's an outline. So Mr. Milton, I'm very, very cautious here of starting to straying into a situation where questions possibly that should have been put to the appellant during the taking of evidence shouldn't be put to me for me to answer on behalf of the appellant.
But in this situation, I think what will happen is that, and we've seen it on a number of other development sites where public open space has been designated or under planning regulations, that the roads, the public highways, are used for parking, for access for the public open space. This will increase the amount of, or decrease the amount of availability in the estate for visitor parking. And I don't think that's something that anybody has considered. We considered it in my evidence that there should be access, public access by designation. That seems to have been overlooked.
Well, Mr. Wilson, I have your representation. I think all I can say is, again, is what's before me is an outline scheme with access to be determined at this stage, and layout and everything else in that respect is to be dealt with at a reserved matters stage. So I think I'd be straying beyond what is before me to consider if I were to start suggesting that there should be car parking laid out for the public open space at this stage. Yeah. And again, I'm looking to the council to either say that I should be looking at it or I shouldn't.
No, on the contrary, madam, you're right. This is an outline application. The details are to be fixed at the reserved matters stage. There's a general obligation to provide the open space in accordance with details to be approved at the reserved matters stage. There's nothing before you that requires any greater specificity than that.
Yeah.
Obviously, the concerns expressed can be taken on board by the council at the reserved matters stage. But at the moment, you have an outline scheme and you can't really fix details that it's for the council to fix later on.
Thank you, Mr. Green.
No,
Mr. Milton, does
I've
that
got-
clarify your point? I mean, my
I can-
concern is, like I said, we're here to,
Yeah,
we're
all
here to
right.
discuss conditions. I don't want us to start straying
no.
into elements of the scheme that would be beyond my jurisdiction to start straying into.
No, but if the council will take that on board as a matter for reserved matters. But my point about the signage for bylaws, which cover the public open space, is part of is something you're dealing with to do with signage.
The signage that I'm considering, that I've flagged up, is in relation to essentially a highways condition to ensure that the site is safe for vehicles to enter, park and exit. It's not relating to bylaws for open space. That condition does not deal, and I can read it out again for you if that would be helpful, that condition does not deal with bylaws for public open space. It is a highways condition to deal with spaces laid out within the site for parking and turning. So it wouldn't be, the
Yes,
condition wouldn't make sense if I suddenly
yeah.
said, and signage for bylaws for public open space.
This is something that highways very rarely take on board. Other inspectors have taken it on board, Elstead, for instance, and parking spaces were part of the scheme because there was public open space. But I accept your point, and that let's hope the council does take it on board, and I expect some form of consultation.
Of course, and when a reserve matters application came in for any of those matters, then there would be a public consultation, and I'm sure that you will contact the council at that stage and work with them, or certainly try to work with them to deal with that.
I do hope so.
Thank you. Right, should we move on to condition 15? Actually, I don't have any comments on condition 15. So condition 16. Yes, my point here was largely that you've got the same trigger point, which doesn't quite make sense. So if it's necessary as a before occupation for that to be submitted, and again submitted to, consistency in terms of drafting, but that's something that could be mopped up. But then you need a different trigger for the implementation of the travel plan. I don't mind what that is, although I would suggest that if you're having a travel plan, then you would want it to be implemented before occupation of the development, and therefore you would need to bring forward the submission of it so that those details could be dealt
Yes.
with. Okay, so condition 17, the construction transport management plan, and then details of what would be within that. Now, this was discussed with Mr. Bell in terms of construction management plans, and the current sort of remit as to what it might include doesn't include a banksman. Now, depending on any reserve matters scheme and how that might look, and how development might be phased or brought forward, it might be necessary to consider the use of a banksman in that area, I feel, in terms of highway safety and impact on residents. So I think that I'm not saying that it would absolutely be necessary, but I think it's something that should be considered as part of a CMP.
Yeah, I mean, we can add flexibility into that to allow if needed.
Super.
But,
Any other comments in relation to that condition? No, right. I don't have anything on condition 18. Condition 19. I'm not adverse to it, and if it's a policy requirement, then I appreciate that there's an element of justification, but I do just flag up, is there any suggestion that the site's contaminated at present, or is that because of farming? Councillor Powell? I know I remember your representation in relation to the fault line and things. In terms of, I'm just wondering about this condition for contamination. I'm not saying it needs to be struck off, but I need to understand why it's justified.
There is some evidence of historic quarrying in the area, which may have involved landfilling, so I think that's why the contamination is there. Do you want to cover the fault line issue at the end? Is that your?
Well, I think we're looking at, well, this is land contamination and remediation. I'm not aware, I tell you what, we'll work through the conditions and then
Yes.
we can come back to that, okay?
Perfect. Thank you very much, ma'am.
So other than that, that's fine, and that clarifies that I don't need to, that condition's fine as drafted then. I just need to be able to justify why things are put on when they're put on. And we're always told that we put too many conditions on things. Right, so sorry, I'm just going back through what I'd flagged up. Nope, and that's fine. I think you amended the condition number, which is fine. I didn't have any comments on condition 21. Condition 22, there were some typos which could be mopped up. Condition 23. Again, it was just the tail end of this condition where it says retained and maintained to the satisfaction of the local authority. I think if something, it is either. Thank you, Mr. Green. Yeah. Condition 24, it refers to carrying out the results of any protected species or presence or likely absence surveys that may have been carried out at the very end of the bulk of the condition. I suggest that should just say results or requirements that are identified in any of those surveys, as opposed to simply results, just to make it slightly more concise.
That would make more sense, yes.
Condition 25 refers to the scheme for the LEAP and the LAP. There's no retention element to that condition, which would be required. Like condition 101, isn't it? I'm sorry, it's terribly, I appreciate it's like teaching people to suck eggs, but it's just, I think when you're having multiple parties drafting conditions as well, everyone has a different way of doing it, and I appreciate that. Condition 28. Again, I mean, there's a question possibly around justification for this, but I'll take it from a heritage perspective, which I imagine is what it's based on because of its location to the castle and its former uses, castle grounds. Councillor Powell, you look as if you could help me with this.
Yeah, there is some archaeological evidence in the area, including a Roman road. So I think it is actually quite important if that's all right with you.
That's fine.
Thank you.
Okay, condition 29, who's submitting the waste management plan to the council? And how are they approving it? So again, just clarifying that.
Can I just suggest on that one, it says Waverley Borough Council, should it not be the local planning authority, just in case that were to change? in
Well,
the
that's, yes, and also there's a consistency element throughout in terms of if you are referring to the local planning authority, some conditions talk about the LPA, and I think some of them say the council. So those need to be consistent as well. Councillor Powell?
So just on that one, I'm just wondering if it's possible to cover the placement of bins, public bins into the public space, just because it's been problematic, I think is the phrase I would choose to use, in terms of who's responsible for them and how they get installed and how they get maintained, whether there's some way of covering that in that particular condition.
I think I take your point in terms of that. Condition 29 refers specifically to a plan relating to waste for the construction, demolition, and excavation phase of the development. Do you mean the use of public bins for that? Because you
Well, that wishing to put too fine a point on it, we have had issues with construction teams not managing their personal waste, shall we say?
right.
Lunch things being distributed and becoming litter, and then the public having to go around and clear them up, which is obviously not something I would want. But there is also a long-term issue in terms of the public space having some kind of bin provision as well, if that's at all possible, Matt.
So I think in terms of the public space, that would come forward separately. In terms of waste management during construction, I'd suggest it would be better dealt with. I mean, it talks about the construction transport management plan. But if that is then dealing with the parking for vehicles of site personnel, operators and visitors, I wonder whether or not that could be brought into that.
Yeah, happy for
in
that to
terms
be
of-
added to the CTMP. I
Yes.
think just in terms of the public open space bins, there is provision in the 106 regarding public open
Yes.
space management that I think could pick up the public bins. point.
Yeah, I mean, the problem is that you shouldn't have something in a condition that's also in a section 106. It either should live in one place or the other. And there's some overlap already with these conditions that sit slightly comfortably, which I'm some of which I'm kind of happy to say could be justified as conditions as well. But if it's dealt with in the section 106, then it would be more part of a comprehensive scheme that came forward under that obligation.
Just on that particular point about, and I do sympathise with the situation where construction workers perhaps might not be as responsible as they could be with litter. It's not something that is necessarily controlled through planning legislation, I would suggest. So I appreciate the point. Whether it's something that's normally enforced through planning conditions is another matter.
Yeah, I take your point. And also in terms of the actual enforceability of it, can go so far. However, I think it wouldn't hurt in terms of if you're going to be looking at parking and things like that and sort of access for construction workers. I don't see any harm to it not being in there as part of a construction management.
No, I think that perhaps could include somewhere for them to put their rubbish, for
Yes.
example.
Which would be a fairly straightforward
Yes.
resolution to it. Thank you. Mr. Green, any comments?
No, Madam, with respect, we agree. It can be covered and should be covered.
Thank you. Condition 30 relates to SUDS. To surface water capacity. I don't have any comments on this. Does anybody else have any comments? Or Councillor Powell, is there anything that you wanted to say in relation to this?
My concern is how we define capacity in the system. And I understand that there's been consultation with Thames Water. I understand that there is a limited amount of flow that they are willing to accept into the system. I also know that the local drain covers lift pretty regularly now whenever it rains heavily. But we found compliance with these conditions to be a really difficult thing locally. And I don't know how to address it. It's more about how you properly define what capacity in a system is in order to truly make it something that can be enforced. And I'm still not convinced this wording is tight enough to do that based on what's happened on other sites. But I don't know how to address it to make it tighter. So I would really be grateful if you would think about how it can be more enforceable in terms of being very clear that there is capacity in the whole system, you know, not just saying there's a tie-in point available where we can put the water in. That's not capacity in the system. I genuinely don't know how you deal with that. And I also don't know how we deal with maintaining orifices that are so small. In my technical experience, it's completely impossible. But I understand that that's not a view that's shared, but leaves are bigger than 10 millimeters. You know, you get one leaf in the system, it's blocked, you know, it's not going to work. But I am struggling. It's the enforcement of the condition that's failed recently a lot, sadly. But it is a completely standard set of wording. So I'm sorry, ma'am. I wish I knew.
No, not at all. And it's helpful to take your view, and I appreciate your concerns. In terms of the bones of the condition, so to speak, you know, the development shall not be occupied until confirmation has been provided. Obviously, those that are bound by the condition, namely the appellant, the house builder, there's only so far they can do to show that they've complied with what's necessary of them in terms of complying with the condition. So they're looking for confirmation that either the surface water capacity exists off-site to serve the development, and as you say, that's not, they're relying on a third party for that. That's not within their control as a developer, or a development infrastructure phasing plan has been agreed, or that network upgrades have been completed. Mr. Green?
No, the difficulty is, as you say, ma'am, it's not the owner or the developer that provides the capacity or can do that,
No.
or indeed can ensure that there is sufficient capacity. That's up to Thames Water. I suppose well, to be more precise, it should say surface water drainage capacity or something like that, instead of just surface water capacity, which doesn't frankly make a lot of sense. But surface water drainage or disposal capacity would be better. But no, the difficulty is it's up to Thames Water to provide that capacity, and they're not here, and the council can't control them.
No. No, and the condition has to be reasonable insofar as what's required as well, within what reasonably the appellant can do, and what is required of them under the legislation. As Mr. Green says, it's a third party, it's Thames Water who.
I think the issue is that Thames have said there isn't capacity for the full flow, which is why such small orifices are required, is to reduce the flow down to a capacity they believe that they have the ability to manage. But that is a very low flow rate. And the reality is the system, I'm sorry, I'm trying not to get techie, but the system, you know, it's a fairly complex system in that particular area just because it's been built on over a long period of time. So building capacity into that system is dependent on lots of different things. And when last conversation I had with Thames Water was they were saying it was going to take them 10, you know, they do 5-year plans. It's not in their 5-year plan to expand that system. So I guess my other concern is on other developments, and we've had a number locally where this has been a preoccupation condition. We've then ended up in the situation where the capacity isn't there, but the development's built and people have moved in anyway, and it hasn't been enforceable as a pre-occupation condition. And I don't know whether there could be a pre-commencement condition about ensuring there is a plan to create the capacity that's needed. Maybe that would help. But I
Well-
don't know if that's considered to be reasonable. The capacity's not there today,
I
and
think
we know that.
the problem is, councillor Powell, is that would not be reasonable on the appellant to create that capacity. And the suggestion with the Thames Water, and that's really something that should be done through the local plan process, because through the local plan process, and I know, and it's very frustrating, but through the local, I mean, there are other boroughs, other districts in Surrey, and certainly West Sussex, that are dealing with this through their local plan and are having particular planning obligations with, I'm going off piste here, but I'll do it anyway, with developers and house builders that restrict flows and things like that in order to deal with this. And those are policy requirements, and they're going through the local plan systems at the moment. And I think that's quite possibly Thames Water as well, South West Water, I can't think now, to justify those as to whether or not they should be included. And that would give, moving forward through the planning system, plan-led system, that gives more control. But when we're dealing with a situation like this, it would be completely unjustified to put a condition on that was unreasonable in terms of what it required.
And I do completely understand your point, and we do have a plan for Farnham that had allocated housing in particular areas, and the network had been checked for for housing development in those areas. But what we are seeing is where we're ending up with housing is not aligning with where we planned for it to be. And the problem with network design is it doesn't work like that. It is very specific to a particular location. So, we do have a neighbourhood plan. It has the infrastructure designed for that housing in that plan. But of course, we're now moving away from a plan-led system into a system that is more about housing numbers than it is about infrastructure. And I guess I don't know how the conditions address that particular scenario. I completely agree with you. I'm much more into plan-led. I'd rather sit down and plan out a scheme, but we're not in that environment right now. But I do understand your point. But thank you for considering the discussion.
That's fine. Unfortunately, I think the two of us are straying into having just a nice little discussion about planning here, aren't we? Rather than actually what we are supposed to be doing, which is looking at the conditions. And I'm going to bring myself back to that. No, it's fine. And in terms of the condition itself, drafted as a condition, my approach is that other than a couple of tweaks, it meets the tests, and so I'm happy to take the views of individual parties on that, but I can't go above and beyond that really if I'm satisfied that it meets those tests. Mr. Packer.
Yeah, no, I was just going to agree with you really. I think this just goes probably as far as it can in terms of not being onerous on the applicant. So it has come directly from the LFA with Thames Water. Obviously, Waverley Borough Council originally drafted the condition as part of the committee report. So I'm comfortable this is an appropriate balance.
Thank you. Mr. Green.
Madam, yes. Can I just suggest that the word written is added before confirmation, just so that there is actually a record. So if there's no development should be occupied, and you're going to perhaps consider how that should be better defined, but no development shall be occupied until written confirmation has been provided.
Yes, thank you. Okay, well, let's move on. Condition 31. I don't have any. The nature of the condition is fine regarding materials, is standard materials condition. Obviously, shall be submitted to and agreed in writing by LPA. Don't like that. And then the development shall be completed in accordance with the details as agreed, not as may be agreed. I think that's a bit strange. As agreed. I think, or as approved, yes, even better. Thank you. The last sentence in relation to soil and vent pipes and other flues, all electrical meter boxes matching the facing brickwork or render wall as appropriate. I'm not sure that that's, I'm not sure I like that very much. Could someone just talk me through it? If you're happy with it and you consider that it's justified and necessary, then it's fine. I don't
think we would necessarily have an objection to it, but it's straying into a considerable level of detail that would be picked up at the reserved matters stage in any case. But I appreciate that the council may want some reassurance at this point in time. But normally speaking, I think that would be a suitable condition for reserved matters detail rather than outline.
Mr. Green, do you have any thoughts?
Well, Madam, obviously, the council thought that it was important that that particular feature be regulated at this stage. Maybe that's based on bad experiences elsewhere, or I don't know.
Yeah, I obviously I can't really comment on the previous developments where this may have led to a concern, but I can understand sometimes that meter boxes and so forth, if they're light coloured against the brickwork, can be quite incongruous within development. Even though it seems a detail, it does sometimes, you know, look incongruous and really stand out, I think, when a lot of effort's gone to other details. But it is a detail. So whether it needs to be stated is a question. But I can, from looking at some of the developments where I've thought, yes, that does actually spoil the look of the street scene, even though it seems something quite minor. You know, typically rainwater goods and so on are often black and sort of aren't too strident, and then you get a sort of cream-coloured series of meter boxes, especially in terraced units and so on, where on the front elevation it can really just stand out.
Okay, I take the point. I'll take a view on it. That's fine. Condition 32. I just wonder here again whether we are duplicating. So this relates to prior to occupation. It's the management and maintenance scheme for hard and soft landscaping. Maintenance in perpetuity for public areas shall be submitted to and agreed in writing with the LPA. The scheme, and obviously that should be a management and maintenance scheme, shall include the long-term management and maintenance of all shrub, grasses and tree planting in public areas, which includes all public open spaces, draining basins and play areas, and the maintenance of other public facilities, including benches and bins and other elements of hard landscaping and public infrastructure works. And I just come back to my point here about duplicating essentially between the conditions and the Section 106 planning obligation and whether or not that's justified here.
I think there definitely is probably duplication with looking at what's the management plan required by the 106. Yeah, of course.
Good morning, Madam. Sorry, my name's James Smith. I'm the solicitor who's dealt with the 106. I think, whilst on the face of it, yes, there is a degree of duplication. If it assists, the 106 obligations are primarily concerned about who is doing the management and the structure of the organisation that will be doing it. The condition, I think, goes into more detail in terms of the planting and the maintenance schedules for the area. But I think that justifies the treatment in both. In terms of the 106 is looking primarily at who that land is going to and how they are then going to manage it.
That's very helpful. Thank you, Mr. Smith. Mr. Milton.
In our opinion, this should remain as a condition within the planning condition as an overarching condition. The detail, of course, in other aspects in the 106 agreement, but the overarching requirement is that it is a planning condition, that it should be managed in the way that is approved. It also affects the temporary stormwater storage on site, which is in the public areas. And these need to be maintained on a regular basis. There are a number of recent examples where this hasn't been done because it's not in the planning condition, and they have blocked, overflowed, and there's no way of enforcing them under the planning regulations.
Okay, thank you, Mr. Wilson. Councillor Powell?
Yes, ma'am. I note that this is all about maintenance. I actually have a concern about it being properly installed before the houses are occupied. We had a case recently where a playground was installed and the maintenance plan was in place, but then it wasn't installed properly. So the whole of the, like the rubber matting that goes into a playground area, it just bubbled up because groundwater came up. So we just ended up with it completely unusable and closed. So we had all these families moving in, and they could never actually use the play area. It took nearly a year to get it fixed. So I'm just wondering if we could have something in there that talks about an initial acceptance of or something, because it's not just about maintaining it, it's getting it right so that the people who are moving into those new homes have a reason, I'm not sure what the right phrase is, but a reasonable standard of facilities around them when they first move in, because it has been a significant issue on one development locally.
Yes, so the condition as drafted says prior to the occupation of any of the dwellings hereby permitted, it says long-term management and maintenance scheme to provide for hard and soft landscaping, future maintenance and perpetuity for public spaces, public areas shall be submitted to and agreed in writing with the LPA. So that's your initial trigger in terms of submitting details of what's to be provided. The scheme shall include the long-term management and maintenance of all shrub, grasses and tree planting in public areas, which includes all public open spaces, drainage basins and play areas, and the maintenance of other public facilities, including benches and bins and other elements of hard landscaping and public infrastructure works. And I think what it's possibly therefore missing is a tail to it, actually, is an enforcement clause. So Councillor Powell, thank you, because I hadn't picked that up, but that the work should be implemented and managed in accordance with that scheme.
I think that's probably fair. I don't think there is provision throughout the conditions unless I find it elsewhere that probably allows for that. So, yeah.
I think it's quite normal. You get the condition drafted and then you forget about the bit that says you've got to retain it, which obviously is useless without. So, thank you. Okay, so condition 33. And again, this is stated practically word for word in the section 106. So perhaps either the appellant solicitor or the council solicitor can assist me as to why it's duplicated in both. So condition 33, for the benefit of everyone here, says prior to the first occupation of any dwelling hereby permitted, written confirmation must be given by the local planning authority confirming that a suitable alternative natural green space has been secured at, and I'm never quite sure how you pronounce this, is it Nash's Wood? Nash's, thank you, Councillor Coburn, Church Crookham. You go all over the place and I'm never entirely sure how to pronounce things. Terribly sorry.
Madam Barry Devlin, Solicitor for the Council.
Morning, Mr. Devlin.
Yes, you're absolutely right, Madam. I'm sure my friend, Mr. Smith, will confirm that the Part 5, Part 1.1 refers to, of the one, Section 106 refers to written confirmation being given by the Borough Council that sufficient capacity within the Church Crookham Sang has been secured to mitigate the impact of the development on the SPA, which is a defined term. This is page 38 of the...
Thank you. Sorry, I'm flapping around up here. Right, carry on. Sorry, sir.
Yes, so I do agree there is duplication between that provision in the Section 106 and condition 33. The Section 106 provision provides that development shall not commence until written confirmation has been given that we're happy that sufficient capacities at Church Crookham Sang, whereas the condition is prior to first occupation.
Right, okay. That makes more sense. Okay, so you're sort of staggering it in terms of, because then obviously prior to occupation, the payment which is secured by the 106 is then due. So is that the rationale for it?
There's no capital SPA payment being made. That's been deleted out of the section 106 because that related to an option which bought into Farnham Park. But I have clear instructions from Claire Upton Brown, the head of planning, that there is no capacity at Farnham Park. It's been taken up completely. So we had to delete out an option for a SANG mitigation, and therefore the only financial payments being made opposite the Thames Basin Heath Spa under the avoidance strategy is for site access management and monitoring of the overall SPA.
Okay. All right. Thank you, Mr. Devlin.
There are deletions in the section 106, and
There
will
are,
become
and,
clearer when you come to look at those.
Yes, and I have been updated on in relation to that. Mr. Smith?
Yeah, I mean, if I could just elaborate, I think as Mr. Devlin's touched upon, originally the SANG was going to be dealt with via this planning condition.
Yep.
When the possibility of Farnham Park was being looked at again, because that involved payment of a financial contribution, we needed an obligation in the 106 agreement. Hence, the clause went into the 106 agreement as well as the condition. Now that Farnham Park is no longer being pursued as a viable option, in theory, I suppose, yes, the obligation could come out of the section 106 agreement if you feel it's not necessary. We may come on to it when we do the 106 discussion, but obviously there is a blue pencil clause in the 106 that enables you to strike out an obligation if you think it's not needed and that the condition on its own is sufficient. I think my only comment on that is if relying solely on the condition, it should probably be a pre-commencement condition rather than a pre-occupation condition. Okay. So that you are satisfied that the mitigation has been secured before the development commences.
Thank you, Mr. Smith. Okay, Councillor Powell, you had your, thank you, Mr. Green.
Thank you, Mr. Green. Thank you, ma'am. Just in terms of the 106 agreement, obviously, as you've heard, you know, there is disagreement from those of us that live in Farnham about whether the SANG provision in Nash's Wood is compliant with FMP 12. We don't believe it is. If you are reviewing the wording of this as you finalise it, if there is a way to leave it flexible so that if SANG did become available in Farnham that was compliant with FMP 12 in terms of it being local to the site, that would obviously, because it could take a very long time for this to get through to the detailed phase and many things can change in that time period. It would be much better to have SANG that was actually local to the site in some way, shape or form. There are, as you've already intimated, you know, we are looking at planning and we are looking at what we do with all these additional houses that are coming our way and how we deal with SANG. And there are a couple of sites that I know that I'm in negotiation with to try to see if they can provide SANG more locally to Farnham. So I don't know if it's possible, and I guess it's a question asked out of naivety more than anything else, but if it is possible to word it in such a way, if what I'm hearing is, I know Farnham Park's full, I know Nashing Wood is available, but it's obviously 6 kilometres away. If there is a way to word it to leave it flexible until the detailed phase, that would be preferable from the community's perspective.
Thank you, Councillor Powell, and it's a perfectly reasonable question. Please don't feel that it shouldn't have been asked. So obviously, in terms for the condition to satisfy the test, it needs to be precise. So I don't know what, I'm happy to take representations. I completely take Councillor Powell's point in terms of what if there were a future situation, but at this point in time, I'm mindful that any condition that was applied would need to be precise to the scheme.
Yes, madam. I mean, this was really what we were trying to achieve with the wording that has now been struck out of the 106, in the sense of the Farnham Park sang, but the council has been quite clear that they do not wish to have that wording in there. That not only referred to Farnham Park, but did refer to another sang that came forward that was strategy compliant. I think what we're mindful of course, is that you need to have sufficient certainty as to what the mitigation is going to be.
Yeah.
Farnham Park is a sang that exists that Natural England are happy with. Naish's Wood is also a sang that exists that Natural England are happy with. I think probably the concern would be that referring to a future sang that is not yet in existence does raise some uncertainty, albeit if it were avoidance strategy compliant, then in my view, potentially a Grampian condition could possibly be worded that allowed for it, but that's something that we might have to discuss with the council. I mean, I'm very happy to say that we'll discuss with the council and send some suggested wording if we think it can be achieved.
Right, Mr. Green, do you have a view?
Madam, in principle, I don't see why you need to specify the sang. What you must do, of course, is ensure that the development can't proceed without one.
Yeah.
But I think in principle, and I'm speaking and now I should make clear without instructions, in principle, I don't see why you can't have a condition that requires or rather prohibits development commencing until an appropriate sang is identified and secured. So yes, and I agree with what's been suggested, but it maybe the council has its own particular concerns, that's all.
Yes, Mr. Devlin, are you able to assist?
Apologies, madam, I'm really not able to assist further.
No, that's okay. I appreciate you're all creatures of instruction. So without anyone here to instruct you, it's a bit difficult, isn't it, really? But I take your point, and I do think if there's a possibility that the condition could be drafted so that work cannot, so that the development cannot be occupied until there is something in place that is policy compliant, then I think that there is possibly a way of broadening this slightly.
Yes.
Whilst still meeting the tests. And I think if that's possible, then I'd be happy to look at something like that.
Well, madam, we have a few days now until closing submission, so perhaps in that period the parties could discuss whether the wording could be improved.
That would be very helpful.
I think that is possible too, and I think we would welcome, my clients would welcome obviously the flexibility if other options did become available.
That would be helpful. And of course, if the instructions of the council are that it's simply that it can't be done, then I will take that into account. But I think at the moment, if we could go away and take instructions, then that would be very helpful. Thank you. Thank you. There you are, Mrs. Powell. See, not a silly question at all. Right, so condition 34. It was simply in terms of agreement in writing, and again, reference to WBC. And then in terms of, so I'll read the condition out because I'm probably making no sense just muttering away to myself up here. The approved tree replacement strategy reference shall be implemented prior to occupation and post completion of the necessary highway improvements on Keepsake Close and Cascade Way. Any alternative replacement strategy shall first be submitted to and agreed, that should be agreed in writing by the council or the local planning authority, pick a name, before development commences, and thereafter implemented prior to occupation and post completion of the necessary highway improvements. It repeats itself a bit. I don't take particular issue with it, but
it's not very well expressed.
It's
but
not the best.
No, because it requires that the approved strategy be implemented, but then in the second sentence accepts that there may be an alternative strategy. I mean, so I understand its intent. It's not particularly well drafted, but it probably does the job.
It probably does the job. It may very well be that if on determining the scheme I was minded to approve, it might be that it would be worded slightly differently within the merits of what it seeks to achieve. So there wouldn't be any surprises, but it might be that it was tinkered with. Were there any comments, Councillor Powell?
Sorry, ma'am. I guess my or the residents' concern is obviously we're digging up trees that are there now. The proposal is to replace them with fairly mature trees, which obviously have a much higher failure rate because they're not very good at being transferred by their very nature. Is there some way to cover replacement, or do you feel that that's already covered in the tree replacement strategy? Because they should be maintained and preserved for a period of time. It's usually 5 years is an aftercare strategy, is a common condition. I know that gets applied at Surrey on various sites.
No, I'm familiar. I'm happy to take that away and consider it if the parties are happy for me to. Mr. Packer?
Yes, I accept the point that's being made. Yes, you could probably add a sentence there to the effect that in the event that those trees die, diseased, whatever, they are replaced, as long as it is within a reasonable time frame.
Of course. Mr. Green, any comments?
No, madam, one would expect tree replacement within, say, 5 or 10 years, whatever the appropriate period is. So.
Yeah. I'll review it in accordance with the tree replacement strategy as well
Yes.
to see what that says, because if it's covered in there, then it may not be that it's necessary to repeat it in the condition. Okay, but I will take that away. Okay, so that finishes my comments in relation to conditions. Was there anything else that anybody wanted to raise in relation to those? I'm conscious, Councillor Powell, that you have something that you'd like to raise. Anything? No, then Councillor Powell.
Thank you, ma'am. As I said in the representation I made to yourself, that there is a fault line that's been identified across the site, and there is a note within the appellant's documents that does talk about the need for further testing, slope stability testing. And given that the fault line does run across both houses, large excavations, big underground suds, tanks, various other things, I do feel that there needs to be some kind of pre-commencement condition or something that makes sure that the layout is fully cognizant of that fault line. So that's one issue I wanted to raise, and the second was maintaining the views of St Andrew's Church. Because I am very concerned that by the time that fault line's been taken into account, and I know we're only considering access, I completely understand that, but we're considering access with 83 homes. And if the fault line which runs across the site does impact on layout, the ability to manage those 83 homes and still maintain views and things is something that does continue to concern me and local residents, ma'am.
Thank you, Councillor Powell. Okay, can I take the views of the appellant then in relation specifically to the first point about the identified fault line? And whether or not a condition you consider would be necessary?
I don't think so, simply because you have the fallback position of, in the event of any approval, the parameters plan being approved as part of that, which defines a development area. It would be with any future applicant to ensure that the layout complied with that parameters plan, and also took into account, obviously, the concern that's been raised and has been discussed at the inquiry about views of the church. So both of those, I think, are still compatible. It's simply a case of demonstrating through the reserve matters, the layout, that they can be safeguarded.
Thank you, Mr. Packer. Mr. Green?
Madam, yes, I think that's right. You have the parameters plan, so that fixes the scheme insofar as it does fix anything. It's for you to decide whether or not that parameters plan sufficiently protects the views of the church. So far as the fault line is concerned, either development in accordance with the parameters plan is possible. If it's not, the developer at the time is going to have to come forward with another scheme.
Yeah, that was my understanding. Thank you, Mr. Green. Thank you, Mrs. Powell. Councillor Powell, I'll take anything you have to say in response, but I'm not going to make a decision here and now. I will take away representations and consider it in due course, because essentially if I decide that I'm dismissing the appeal, then I don't have to think about this anyway.
Thank you, ma'am. I mean, I would just say that, you know, the fault line will not just impact on the layout of the buildings, it would also impact on the layout of roads, the layout of the SUD system and the large underground tanks, various other things. And it would, if that slope stability testing comes back in the way it has in other areas locally along that fault line, it will have the potential to have a very significant impact on the layout, in my technical opinion. And therefore I would ask that you do consider that there is at least some way of ensuring that it's investigated before a detailed submission is made. Otherwise we'll get a detailed submission in and then it will have to change again, which is not helpful to anyone at the end of the day. But I absolutely understand that you need to go away and consider what your thought process is, and thank you for considering the issue.
Thank you, Councillor Powell. Were there any other comments from anyone in relation to the conditions? Mr. Milton? No. Mr. Packer? Mr. Smith? Barnes? No. No. I feel like I'm calling a register. Right, that's fine then. In that case, that concludes my comments in relation to the draft planning conditions. I will tomorrow circulate those in electronic form so that you've got a slightly more coherent record than my ramblings up here. And apologies that wasn't done before. As I said, it would normally be done, normally in advance of opening, but I wasn't able to, and I didn't receive it electronically until today. And that's not a criticism of the appellant. I appreciate it was submitted yesterday. Right. Does anybody want to break before we move on to the section 106, or is everybody happy to keep going? I don't mind. Councillor Powell?
Sorry, just two things. Is it possible to have a copy of the section 106 that you're discussing, just because that would be easier for me to follow? Perfect.
Do we have some paper copies?
Amazing. And the second comment is, please ignore the information on the site visit. Apparently, Mr. Freeze now come back and said the document he provided you with yesterday is still good.
Okay. So yesterday I accepted an inquiry document that had a list of houses.
And a map.
And everybody was going
Yes.
to be in. And I'd intended to essentially work my way up towards
Yes.
the appeal side. And that's what I'm still doing. Is that right?
That's right, ma'am. Apologies for the confusion.
No, that's absolutely fine. Absolutely fine. Right. Mr. Milton, Mr. Milton's got a copy of the 106. Good. I've received a SIL regulation compliance statement in the run-up to the inquiries. Thank you for that. And that 106 includes a blue pencil clause. So if there were anything that I deemed should be removed, then that's within my power to do so. Could we start at Schedule 1, so parts 1 and 2? Okay, and then could one of the parties, essentially, I'm imagining following the note, talk me through the schedule, what's secured, how it's secured, and that's so that I can make any notes that I need to. If I have any questions, I will ask them as we go through.
Shall I just talk through what's proposed, madam?
Yes, please.
Well, as is set out in the note, the agreement through Schedule 1, Parts 1 and 2 require 30% of the dwellings to be provided as affordable housing, and or first homes. I mean, first homes are affordable housing, obviously, but they're treated slightly differently and dealt with in a separate part of the schedule because the mechanics of their delivery is different in the sense that they're not transferred to the registered provider. So 25% first homes, of 58% of the affordable units affordable rent, although it is subject to a lower rent cap than affordable rent is ordinarily in order to meet the Waverley specific need. So the definition of affordable rent, you'll see caps the rent at slightly different levels depending on the size of the units, because that's what has been identified as meeting the local housing need in Waverley. And 17% shared ownership units. They're to be delivered in accordance with an affordable housing plan submitted prior to the commencement of development and approved by the council. That will approve obviously the detailed breakdown of the location of the different units and their tenures, and obviously where they are in the development. The agreement then requires those to have been transferred to a registered provider or a contract being placed with a registered provider prior to more than 50% of the open market units being occupied, and that they've all been delivered and completed and are ready for occupation prior to more than 75% of the units being occupied. There are then the sort of relatively standard provisions relating to nominations and eligibility for occupation that ensures that they can only be occupied by those in housing need as affordable housing, subject to the usual exemptions for right to buy and chargees, exercising a power of sale, etc. The first homes provisions, I don't know how much detail you need me to go. They are the national standard template first homes provisions. Do you need me to drill down into those, or essentially they require the units to be provided at the discount of up to 30% market discount, and that to be retained subject to the usual exclusions on subsequent sales.
No, madam. I think my friend has very adeptly summarised those provisions, madam. Nothing to add. Thank you.
Sorry, ma'am. I would just point out that 24 out of 83 is still not 30%. It's still 29%, and it would have to be 25 to make it 30%. I don't know how you deal with that, but that fact does still exist.
Sorry, that is a good spot, and apologies for my omission. There is also provision in the agreement for a contribution to represent the partial element of a dwelling that would not be provided in the event that 30% doesn't equate to a whole number. So you're right to spot that, but it is covered through a financial payment.
Thank you, Mr. Smith. My understanding when I looked at the case initially was that it was partly provided on site and that there would be a financial payment to make up the shortfall in the percentage, so to speak. But I take your point. Thank you, Councillor Powell. So part 3, managed land. So Mr. Smith, if you would canter through that with us, please.
Yeah, part 3 contains the obligations dealing with the management and maintenance moving forward of all of the publicly accessible areas of the site. So this is the open space that's been discussed previously, the play areas. It also covers any areas of communal car parking, sustainable drainage features, and indeed estate roads as well, so which may bring some comfort in terms of the point that was being discussed previously. The management plan that is required to be approved under this will cover the management of estate roads. And I suppose in theory, therefore, if there was perceived to be an issue with people parking on the estate roads that shouldn't be there, that could be covered off through that management plan. The fundamental issue is to have a management plan for the development approved prior to the commencement of development. That will set out the management and maintenance arrangements for all of these areas. Broadly speaking, they will go to the management company, but in theory, the management plan could cover other arrangements. There is some provision in there as to timing, is in terms of the public open space, the play areas. The main leap has to be provided prior to 80% of occupations on site, and the smaller play area, the lap, has to be provided prior to the occupation of 40% of the areas on site. And all of the open space also has to be provided before more than 80% of the dwellings on the site have been occupied. Thereafter, the drafting requires that upon their completion, those areas have to be transferred to the management company and made available for public use in perpetuity.
Sorry, there's a slight discrepancy, unless I'm wrong, and if I'm wrong, please feel free to tell me I am. Condition 32 that we talked about, sorry to jump back to them, talked about prior to occupation, a management and maintenance scheme, whereas the management plan in the 106 is pre-commencement of development. Is that right?
I mean, that is correct, yes. I mean, this management plan is, as I alluded to earlier, is covering slightly different things in that it's concerned primarily with the structure of the management company arrangements.
Right.
But yes, there is a slight, I mean, to the extent, I suppose, that the two plans cover the same thing, they will either be submitted as a single plan prior to commencement, in which case the condition will have already been discharged, or it may be submitted in two stages. But fundamentally, the arrangements will have to be approved in the main prior to commencement, and it may be that some of the more detailed sort of maintenance arrangements for the open space and the planting, etc., is prior to occupation.
Yeah, I was thinking as well about the Councillor Powell's comment and the play areas. I mean, I think it probably works in that the condition refers to prior to occupation of any of the dwellings scheme would come in, and then the 106 provides that 80% for the LEAP, 40% occupation for the LAP, and 80% for the open space. So they work in tandem with each other, don't they?
Yeah, I mean, the condition isn't, as I understand it, the condition is not setting out any triggers for their delivery as it stands. The 106 is therefore, I suppose, adding that level of detail in that when we spoke with the council, it was identified that it would be beneficial for at least one of the play areas to come forward earlier, so that there is some play space in place for families moving into the development in the earlier stages. The overall quantum has to be delivered prior to 80%, so everything by 80% effectively.
Thank you, Mr. Smith. Mr. Devlin, did you have any comments?
Yeah, madam, nothing to add. Thank you.
I'm grateful, thank you. Mr. I don't know whose hand was up first because sorry, I wasn't looking. No, Mr. Milson, please. Councillor Powell says it was you, so off we go.
Yes, there's nothing in this or in the previous discussion that allows, that sets out what happens if the management company goes into receivership or bankruptcy or administration. Is there an escrow bond to cover the management in perpetuity? It's supposed to be in perpetuity as according to the conditions. And in perpetuity without designation doesn't mean anything. Statutory designation.
Thank you, Mr. Milton. I take your point. Mr. Smith, could you allude on that? The management company isn't a defined term.
Management company is a defined term. The management plan is required to contain the financial arrangements that will be in place to ensure that the management company has sufficient funds. That has to be submitted and approved by the council prior to the commencement of development. It also has to contain details of effectively the service and estate management charges that would be charged by that company in order to provide it with the bulk of that funding moving forward. The requirement in perpetuity is obviously to allow public open space to be used in perpetuity. The obligation obviously to manage will equally run with the land through the 106 through the requirement to comply with the management plan.
Thank you, Mr Smith. It's helpful. Mr Devlin, was there anything you wanted to add?
Just to say, Madam, that it's unusual for a development of this type to be bonded or guaranteed or contain any step-in right for a council. So we were quite happy with these provisions. These are absolutely standard provisions for a management company.
Thank you, Mr Devlin. That's helpful. Mr Milton, was there anything else you wanted to say?
The fact that it's been used before doesn't mean it's right. We have 3 or 4 examples across the county of such management companies going into receivership. And in fact, the county council then having been forced to come in and take over under the Open Spaces Act 1906 as public open space. There is a local sang which is supposedly a private sang with public access where the company has gone bust, and they are relying, the past director is relying on the escrow bond, but the council has not stepped in. I think this is a system, a fault system within possibly Waverley's interpretation, but I think it is falsely made.
Thank you, Mr Milton. I take your point. Did anyone want to come back and comment on that?
I mean, other than to reiterate that the arrangements will be approved under the management plan, they do include ongoing service and estate charges towards the ongoing maintenance of the public areas. I don't know the circumstances of the management companies that are being referred to and whether they were private management companies or estate management companies, essentially. It's a well-established mechanism for maintaining open space. I mean, SANGs might be a bit different. I know that SANG was referenced there. Clearly, a larger SANG is a different case, but that's not what is being proposed here before you today. So, you know, as Mr Devlin has alluded to, these are the council's standard requirements, and we think that they're adequate.
Thank you, Mr Smith. Councillor Powell, you had a question?
Yes, thank you, ma'am. Just in terms of one of the issues that we have, sadly across a number of the new developments, including the Abbey View estate, is that they obviously pay a service charge to, you know, as has just been outlined, and it's quite a significant service charge for the facilities to be maintained each year. But there's no requirement for there to be a report to them as to the ongoing condition. And it's the same for the council. I mean, I am spending an inordinate amount of my time at the moment trying to get SUDs maintained across Farnham. And there's no requirement in any of the documentation that exists in 106s or anything else about an annual report that says, you know, we have maintained the SUDs, we've maintained the LAP, the LEAP, you know, in line with the management condition report. I mean, just some kind of annual report that requires the management company to prove that they've been out there, they've done what they should have done, and it's come back. Even if that report just goes, I mean, like there's a residents association in Abbey View. If it went to the management association every year as a record of, you know, this is what we've done, or to the council, whichever you believe is more appropriate. But at the moment, it appears like the management plans are written and then there's no recourse against those management conditions at all. And it's becoming quite a significant problem. I mean, there's also no legal requirement for anyone to track where the SUDS designs are going in or how they work. It's entirely down to the management companies on individual sites. And that is, frankly, stacking up a problem for the long term. So anything you can do in terms of, if you feel you're able to, include some kind of annual reporting requirement to the relevant council at least, or to a residents association, I would be grateful if you could consider that, because I think that would help to solve a lot of problems that might come out of this. Thank you, ma'am.
Thank you, Councillor Powell. Mr Smith, any comments?
I suppose my comment on that would be that under one of the things to be approved under the management plan is small c in the definition to provide a means by which the borough council may verify compliance with the management plan. Now, that would appear to me to be the forum for that kind of reporting to be imposed at the point of approval of the management plan, obviously. And I'm not sure it's necessary to expressly state it within the drafting. That is within the council's gift at the time the management plan is approved to impose a reporting requirement should they see fit.
Thank you, Mr. Smith. Mr. Devlin?
Nothing to add, Madam. Management plan is defined on page 11. For those not familiar with section 1/6.
Yeah, thank you. Okay. So moving on to part 4 then, please. Self and custom build plots.
Yep, part 4, sorry, my note says schedule 4. That's an error, apologies. This contains the obligations relating to self and custom build plots. There is a policy requirement to provide 5% of the dwelling plots as capable of coming forward as self and custom build plots, and this drafting provides the mechanism to seek to achieve that. In essence, the plots have to be laid out and serviced prior to, I think, the occupation of 30% of the dwellings in the development. They then have to be marketed in accordance with an approved marketing strategy for the self and custom build plots for a period of at least a year. There is a reporting sort of mechanism built into that after 6 months in terms of updating the councils to progress, and ultimately, if after a year they cannot be sold as self-build plots, there is a mechanism whereby they can be released for standard market housing. But obviously that's subject to satisfying the council that all attempts have been made to sell them as self and custom build plots.
And presumably the council have a record of the number of plots that fail in that regard. Do they?
Sorry, Madam. I don't know offhand. If you wish, I will check that with my colleagues in the planning department.
No, I don't think it doesn't go to the heart of it. It was just thinking out loud. Okay. I don't have any questions in relation to self-build. Moving on, so then we've got part 5, which is the SANG and SAM, which we touched upon. Sorry, I should ask before we moved on if anybody else had any questions in relation to the self-build plots. No. SANG and SAM. So I think you probably already updated us on the position in relation to the SANG and SAM. I'm wondering, insofar as the condition might be amended, whether or not that would also then require an amendment to the section 106, which currently only refers now to the church, cook and SANG.
I think that is the case, yes. If we agree some revised condition words, we may need to just make a very minor amendment to 1.1 to make sure that the wording is consistent. Myself and Mr. Devlin can liaise over that and make sure that's affected prior to the completion.
Okay. And in terms of actually, so when it says sufficient capacity within the church, cook and SANG has been secured, right? Okay, that's fine. I talk to myself at home as well, so it shouldn't be a surprise that I'm up here doing the same thing. If you do decide suitable wording for a condition with an amendment, could you also at the same time include a note to me of any necessary amendment to the section 106 as well? Is that possible? That would be, well, it would be necessary. Thank you. Mr. Milton?
In the event that the Church Crookham Sang is not available for whatever reason, how is this condition going to be affected? There doesn't seem to be any provision of an alternative, or what happens if it doesn't become approved.
That's what we're just discussing at the moment. So the fact that an alternative policy compliant sang or means of securing in order so that if it wasn't possible, there is an alternative. Similarly, alongside what Councillor Powell said earlier, that there might be a more suitable arrangement, a more suitable sang. So it would also cover that basis as well. So that's the wording that the parties are going to go away and agree. Okay. Okay, and then if you could just talk me through the county council obligations. I appreciate they're not here, but would be helpful.
Yep, just in brief. Schedule 2 sets out the county council obligations which relate to transportation and highways matters. There is the payment of a financial contribution in the sum of 162,860 to the county council, which was requested by them in order to be put towards sustainable transport improvements in and around the town centre in Farnham. That's payable 50% on commencement of development and 50% prior to first occupation of the development. There is an obligation which really is drawing out a detail of the travel plan, I suppose, but within the travel packs that are to be provided to the initial occupiers of all dwellings, there will be an electric bike scheme, which will require the provision of either an electric bike up to the value of £1,000 or a voucher for £1,000 towards an electric bike if they want to buy a more expensive model to the initial occupiers of each household. That is secured through paragraph 4 of part 2. There is a travel plan audit fee of 6,150 to be paid to cover the monitoring of the travel plan by the county council, payable prior to the commencement of development. And then there are also the standard provisions regarding the implementation of the approved travel plan. I suspect, again, you will note that there is a degree of duplication with the condition here, albeit there is a small difference in that there is a bit more detail in terms of how that travel plan will be extended, dependent upon the monitoring reports and the outcomes in terms of whether it's achieving its targets. But that's in a nutshell of the county council obligations.
Thank you, Mr. Smith. The council have any comments?
Nothing to add, man.
Okay. Were there any questions, Councillor Powell? No. Okay. All right. And have I received up-to-date office copy entries? I may have done, but could we just confirm?
The council has them. I don't know whether you've been sent them, madam. We can obviously arrange that.
They may already be floating around pinned somewhere, but if
I have actually set the register title, pardon me, not the filed plan. Up-to-date office copy entries will be produced to you by the end of the inquiry, madam.
super, that'd be helpful. Thank you, Mr. Devlin. Okay, does anybody have anything further they want to add in relation to the section 106 before we wrap up, Mr. Smith?
May I just ask on timings, madam? We have the 106 being signed by our final landowner this afternoon. It will then be back with the council. Mr. Devlin has indicated that it might take a short period for it to be sealed. I don't know whether this was discussed in my absence by Mr. Litton, but is it okay for the 106 to follow on a short period after the close of the inquiry, or are you expecting it prior to close?
By Tuesday.
By Tuesday.
No, it's fine. I'm happy to. I'm happy for. How long do you think you're going to need?
I'm in the hands of Mr. Devlin to a degree there.
Apology, madam. Due to the need for me to obtain a specific authorisation
Right.
from the head of planning, I can't see all the documents. I did have a word with her last night at a planning committee,
Okay.
and I was hoping to meet with her this morning, but didn't. I would imagine 1 week will, post finishing of the inquiry, will
Okay.
allow sufficient time, madam.
Okay, that's fine. Mr. Green, are you happy with that?
Madam, yes, it sounds that there may be some refinement of the planning
Yeah,
obligation.
that's what I'm thinking, is there might be some amendments to be initialed
So
as well.
can I suggest 2 weeks from the date of closing submissions?
Yep, that's perfectly happy with that.
So-
So, and if it suddenly turns out that there's a problem with it, then obviously the sooner you flag that up, the better, and then we can reassess. But initially, if 2 weeks post-closing, that would be that would be good. I will get the case, I'll confirm that to the case officer and have them circulate that to you so that it's on record as well. Okay. Right, so if there's nothing further with the section 106, Mr. Devlin, oh, I thought you were poised to speak then. Right, so we've dealt with the conditions in the section 106. So what remains, according to my housekeeping, is the site visit arrangements. I have what is my ID 21, which is the list of properties to go to. And I propose to go to those first, and helpfully it's marked out where those properties are. So I am intending to commence the site visit at number 4 Cascade Way, which is Mrs. Oldroyd's property. I will need somebody from the, obviously, appellant side and the council side to come along with me, and interested parties if they wish to. My suggestion, I found it a little bit difficult from obviously the itinerary follows the landscape viewpoints, which is fine. I found it a little bit difficult when I looked at it alongside the LVA to figure out which direction I should travel in first, in terms of, because there are multiple footpaths and things. So I'm going to suggest, and I'm happy to be advised otherwise, but I'm going to suggest that we meet at number 4 and do the residents, and then set off and cover the viewpoints. Now, in terms of viewpoint, it might be better on my screen, actually. No, viewpoint, and cover everything, including viewpoint 10, which is slightly further up to the north, and around the Farnham Castle we'll do as one big group, if everyone's happy with that. I mean, I'm happy to do an unaccompanied site visit if you are happy for me to. However, if interested parties want to come along, then it's going to have to be an accompanied site visit. So I don't mind. Obviously, I can't hear any evidence. What I am going to suggest, though, is that I certainly intend to do viewpoints 12A, 12B, and 13 unaccompanied, because they are the other side of Farnham. And so I don't see the point of us all getting in cars, driving over to park up to watch me stand there and take some notes and some photographs. So I'm happy to take a view. Are there any interested parties that want to come on the entire site visit in terms of walking around all of the footpaths? Councillor Powell?
I have been asked by the residents if I would come with you, if you don't mind, ma'am. Sorry. I'm happy to not do the ones in the south, but if it's possible, I would like to.
That's absolutely fine, in which case we're all going. So council and appellant, get your walking shoes. We're off. But that's absolutely fine. That's perfectly proper. Okay, so is everybody happy with those suggestions?
Yes, that's fine. I haven't bought my walking boots, but that's my fault. As I mentioned earlier, actually, we have got a slightly updated version of that walking route, only to add in simply the off-site highway works on the plan, and have the plans of those off-site highway works available to you. We have copies that we've printed out, which we're happy to distribute now.
Okay, yeah, that would be helpful. Thank you. The one other point in terms of site visits as well was that the viewpoints for 5A and 5B, which are down in the town, it's probably easy that if I do those entirely unaccompanied as well. Mrs. Powell, I can't imagine you feel the need to come with me. That's wonderful. Thank you. very much. I'm going to take the updated site visit itinerary as an inquiry document. Okay. Right, so it's 11. Sorry, councillor Powell.
Sorry, just one more thing. The residents have asked me to communicate that they have cleared or they are planning to keep 2 parking spaces in Keepsake Close available for you. But I guess that might not work because there's going to be at least 3 people. But the alternative place to park is the car park near Waitrose, and just to walk from there is probably the nearest public car parking if people don't want to park on the roads. But there will be 2 spaces, so there will be somewhere for you to park.
Thank you, councillor Powell. I did think actually I thought I'd go and grab, there's a parking space up near where the proposed access would sort of go through. And I was thinking I might park there if it was free. So I will, but knowing now that I can park, I will go and have a snooze around. Thank you very much for that. So 11, it's some distance, well, it's not some distance to the site, but it's also about to be lunchtime. So I'd suggest that everyone has a break. It's probably about 20 minutes to Farnham from here, isn't it? Half an hour? Yeah, okay. Well, you haven't seen how I drive. Could be 20 minutes. So I suggest everyone has an hour for lunch and then we meet on site. I'm going to say 1 o'clock. I know that seems like quite a long way away, but by the time everyone's actually eaten and then travelled, and it allows for a bit of traffic as well on the roads. Is everyone happy with that? Okay, so those are the site visit arrangements, which is good. I don't think there's anything else. Mr. Green, was there anything else you wanted to raise?
No, thank you, madam.
No. From the council side, anything?
Only just to clarify where we're meeting, did you say we'll
Number
start at number
4.
4? Yep.
Yes, please.
Thank you.
Okay, well, in that case, we have heard all the evidence. We've dealt with the planning conditions and the section 106. I will carry out the site visit this afternoon. I have quite a long journey home tomorrow, but I will do my best by close of play tomorrow to circulate the conditions and an updated ID list. Okay, so that they can be worked on. And then we will reconvene next Tuesday at 10 a.m. online for closings only. So I won't hear any more evidence. Any update on possible costs applications for me to bear in mind?
Well, Mr. Litton isn't here, but as far as I'm aware, there are no instructions for any costs.
Thank you.
Likewise,
Green?
madam.
Right, okay. Well, in that case, thank you very much for everyone for the last few days. And I will see some of you, I imagine, virtually on Tuesday. And we are adjourned until Tuesday. Thank you.
Thank you.